24 CV 52569, 25 CV 16784, Joe Bong versus Douglas County School District. And I have the parties on the line. Somebody remind me what we are doing here today. I know that there's a motion to compel that is still outstanding. Are we having argument on that?
I believe that's the only motion that's still pending, Your Honor.
Okay. And that is in the 25 CV 16784 case, correct?
I believe it's the 6-9 case.
6969. Just a moment. Oh, this is the production of the destruction and records management documentation?
Correct, Your Honor.
Yes, I did read that over the lunch hour, or reread it, I should say. Ms. Bong. Lunch hour. Ms. Bong, do you wish to make argument?
Yes, sir.
Sir.
So,
Your Honor, this destruction motion was filed before the sanctions ruling. The existence and deletion of the alleged emails were already in dispute. The original RFP sought the PRR and related communications. The PRR was produced and no specific additional documentation was identified at the time of the motion to compel as existing and within my possession of control.
Did you say the PR?
The public record PRR. So the records request itself was produced.
Okay.
Respondent sanctions position assumes that because I use quotation marks in the complaint, I must possess the underlying writing. Quotation does not establish present possession, custody, or control. ORCP 46 requires proof, not inference. If respondent contends emails once existed but were deleted, OR 166-400-0030 subsection 12 requires destruction documentation to exist and be permanently retained. No such documentation has been produced. In the absence of destruction documentation, there is no evidentiary confirmation of existence, deletion, or compliance with records law. If the court believes additional documents exist within my control, I respectfully request identification of those documents so that I may comply.
Are you done with the argument, or
Yes,
do you have more?
That's all I have, Your Honor.
So did you send over a request for production of these documents?
I don't know what production of the documents they want. That's all I have, which was what I produced.
I'm asking you. The way I read this says that you're seeking the production of destruction and record management documents from the respondent, correct?
That's in response to the ORCP 46 sanctions motion. For consideration.
I understand, but did you send a request for production to that nature? Because I'm not sure what is this motion that I'm.
This is not a discovery motion, Your Honor. This is in support of in opposition to the sanctions motion. It's not a discovery motion.
Okay, and what was the OAR that you?
Let me repeat that. It's OAR 166-400-0030 subsection 12.
OAR 166-400 300
400-0030 subsection 12.
Sorry, 166 400
0030 subsection 12.
Okay, Mr. Mersereau.
Well, I think Your Honor hit the nail on the head. This is, Ms. Bong seems to state that this is not a discovery motion. It was filed as a motion to compel, although it doesn't contain the words motion to compel, it is a motion to compel. And the answer to the court's question is no. There was never a request for production for these documents. So it is entirely inappropriate for Ms. Bong to seek these records for the first time in a motion before this court instead of just asking me for them. As a motion to compel, of course, UTCR 5.010 applies, requiring Ms. Bong to compel or to confer before filing this motion. She did no such thing. Her motion does not represent that she conferred. So you have a motion to compel that does not follow an RFP and that was not conferred on. And I think each of those is an independent reason to deny this motion.
Ms. Bong.
Your Honor, this is not an RFP regarding discovery motion. Your Honor, this is regarding his ORCP 46 sanctions motion. If he is saying that he deleted those emails, and as that's the premises of the sanctions, then they should produce deletion emails or deletion records. UTCR does not cover the motions to compel outside of discovery.
You're saying that this is a response to his motion to dismiss?
Correct, Your Honor.
Didn't you file a response to his motion to dismiss?
I did, Your Honor, but this is a supplement to that.
And so you are asking for affirmative relief or response that is defending against Mr. Mersereau's motion?
It's in support of my opposition, Your Honor. It rests on the existence of these supposed deleted.
So, okay, let me ask it this way. Am I to read this supplement, as you call it, as a argument that if Mr. Mersereau's motion to dismiss is warranted, then it's just an argument that he should provide these
As a evidentiary requirement for him to show that these documents at least once existed and were deleted as they claim. At this point in time, it's only the word of counsel claiming that they have deleted these supposed emails.
Right. And so you are trying to compel him to produce certain documents.
That is correct, Your Honor.
That would be a motion to compel, and that has to be done in a procedurally appropriate way. And so this motion is denied. Is there anything else?
Then I request that the sanctions motion be stayed until we can get this documentation compelled, Your Honor.
Well,
I
go ahead,
apologize.
Mr. Mersereau.
I apologize, Your Honor. That motion has been heard and decided. There's no reason to go back into it. Not from my view.
I granted the motion for sanction, and I think it's independent of what you're even alleging here, Ms. Bong. And so that request is denied. Is there anything else?
Yes, Your Honor. With regard to the trial scheduling, I need to clarify if this has been converted to a bench trial or if it's still a jury trial. And if it's a bench trial, I would like to file motions to preserve my objections to conviction.
Yeah, and this will be a bench trial, and you may file that objection.
Thank you, Your Honor.
Okay, have a good day.
You as well. Thank you, Your Honor.